Hello guys and welcome to another version of this tutorial legal method, a course designed by Bentex Tolapia at Northeastern University. So in this week 3, we are going to look at classification of laws. So quickly, I will be so precise and hitting the nail on the head. So the first thing we're going to look at is the introduction. So as introduction, it says the classification of law is fundamental, meaning is important. It's fundamental part of legal method, meaning is very important in legal method. Why? Because as it organizes the vast body of legal rules into conceptual categories. So classification of law has organizes all the many body of legal rules into a very conceptual category, like a very understanding category for one, analysis and application, so that we know how to analyze them and know how to apply them. These classifications are not mutually exclusive. They are not mutually exclusive, meaning they are not isolated from one another, but they provide clarity about sources, function, and enforcement of the legal norms. So they give you a clear way of understanding these legal norms and how they apply and what are their enforcements, etc. So this is just the introduction. You can complete that. So the first classification of law we are going to look at is the common law and civil law. What is common law and what is civil law? This is classification of law based on the system of law that is applied in a particular country. Like Nigeria will apply common law. There are other countries that apply civil law. So now let me explain to you the differences. Common law comes from England, while civil law comes from Rome. You understand? Common law is based on judicial precedent, while civil law is based on codified rules. Meaning of codified rules is those rules that were written. They have written down all the rules in civil law, but in common law, it is based on judicial precedent. What is the meaning of judicial precedent? Judicial precedent means the decision of higher court is binding on lower court. So if a higher judge make a decision, judge of higher record, the supreme, the appeal, etc. If they make decision, the lower court must follow. So there is something, let me give you a cheat. That is what we call superior court of records. And those superior court of record, if they ask you anywhere you hear superior court of record, they are called the courts that were listed in the constitution. Those are called superior court of record. So there are inferior courts. Those ones are not mentioned in the constitution. There are superior court and inferior court. Even at the superior court, it is hierarchy. The first at the top comes the Supreme Court, then comes the Court of Appeal. At the level of Court of Appeal, there is Sharia Court of Appeal. And then after that, there is High Court. At the level of High Court, there are many courts. For example, Federal Industrial Courts, National Industrial Court, the High Court FCT, the Federal High Court, the High Court of the States, etc. Those courts, they are at the level of High Court. Then below it, there is that's the last court that was listed in the constitution. No, that is customary court. Yes, customary court of appeal, there's Sharia court of appeal and all those things. Then after that, all those magistrate court and all those things, they are not listed in constitution. So this court hierarchy, if a lower court make decision and higher court make another decision, then that decision of lower court is not binding. The higher one will be binding. So common law is based on this particular thing. Do you understand? But civil law is not. Civil law, the rules are written. So any judge will follow that particular rules that were written. Do you understand? So that's the difference. So let's go to the notes. Common law originated in medieval England. The meaning of medieval is the middle age between the ancient and the modern, the middle one, the central one, that moment where knowledge started emerging. That's the medieval era. Okay, and it is based on judicial precedent and the doctrine of stare decisis. Just like I told you what judicial precedent means, right? That decision of higher court is binding on lower courts. So that's what common law system is. So also the doctrine of stare decisis, let the decision stand. Somehow similar. Then he said in Nigeria, the common law tradition was introduced through colonial reception statutes, notable Section 32 of the Interpretation Act of 1964, blah, blah, blah. So we said common law is from England. Then why do we have common law in Nigeria? This was is telling you. It came to us through colonial. And when the colonial masters came to Nigeria, they come together with three things. That's the received English law. We call them the received English law. So anywhere you hear the received English law, know that it contains three things. One was struck out. We don't use it anymore. But these three things contain the received English law. One, common law. Two, equity. And three, the statute of general application. But we don't apply the statute of general application after 1st January 1900. We don't apply it anymore. Do you understand? So common law and equity and the statute of general application, they form received English law. These received English law are laws that we have gotten from England. Do you understand? So they become part of our law. Okay, so please take this note, because if you can jot it down, because it's very important. So that's why we apply common law in Nigeria. So before I leave this page, let me explain to you something very important about the definition of common law, in case you are asked, maybe a lecturer asks you in the class, what do you define common law? So please, you can say common law are laws that apply in the four realms of the United Kingdom. Common law are laws that apply in the four realms of the United Kingdom, which is based on judicial precedent and the doctrine of stare decisis. It was harsh, but later equity mitigated the harshness by introducing fairness and equitable way of dispensing justice. When you give this definition to common law, you have made justice. Or you can shorten it by saying common law refers to those laws that were applied or that are applied in the forums of the United Kingdom, which is based on judicial precedent. You can keep quiet there. Okay, so what are the forums of the United Kingdom? That's Scotland, Ireland, Wales, and England. The forums of the United Kingdom are England, Ireland, Scotland, and Wales. Ireland with ICE, then Wales with WALES. These are the forums of the United Kingdom. So that's the definition of common law. Common law are laws that applies in the forums of the United Kingdom, which are England, Ireland, Scotland, Wales, and is based on judicial precedent and the doctrine of stare decisis. So just if you give explanation of that, you have explained in a very simple about what is common law. Then let's go to what is civil law. Just like I told you, other countries apply civil law. Just like we in Nigeria we apply common law, other countries apply civil law. So civil law derives from Rome. I told you the difference is that civil law comes from Rome. And civil law is based on codified rules. Like, what do we mean by codified? Codified means they have written down, they have brought it and jotted down, they have written a book, or they have written something that they use as their laws. Okay, so these codified laws are in continental these codified laws are in continental Europe. An example of it is the Code of Napoleon of 1804. That's the example. And the civil law is characterized by comprehensive statutory code rather than judicial precedent. So it's a comprehensive. Comprehensive means a very detailed and understanding statutory code. That's what they do. They jot down everything, all the laws in civil law, it is written. You understand? So that's it about the received English law. That's it about the civil law. So now let's give example. Example of common law jurisdiction include, like, countries that apply common law is the United Kingdom, the United States, Nigeria, where courts rely on a precedent and judicial decision. Like also Nigeria, our courts rely on what judicial precedent are. Then for civil law system, are prevalent in continental Europe, Latin America, there are Latin America and other part of Africa, etc. So that's just about the example. So now the next thing you need to understand about this is what is the understanding of common law and equity. What is common law and what is equity? Just like I told you what common law is, now you need to understand what equity is about. You need to understand what equity is about, okay? So within the common law tradition, a further distinction exists between common law and equity. Now, how do you understand between common law and equity? Please, before I go into this note, let me explain to you the historical aspect of what is common law and what is equity. And the reason is because they will follow you to your phone. Please listen attentively. Make sure you are jotting something down so that you understand this area. Common law comes to England after the King First of, I don't know, is it Alexander? I've forgotten his name. He invaded England and he became the ruler of England. Do you understand? So After he became the ruler of England, he now assigned his commissioners to go around the four realms of the United Kingdom. After he invaded the United Kingdom, he assigned his rulers to go around the country. And when they go around the country, they now started ruling people based on their own interests. Do you understand? They started ruling people based on what they want. So after they rule, what the judgment they will now be sending it back to the king. You understand? They make judgment, they will be sending it. Judgment, they will be sending it. So those papers they are sending, they serve as judicial precedent. Do you understand? So, for example, let's say one of the commissioners went and make judgment about a case. And after that, the same case with the same fact happen here. They will use that kind of judgment here. That's how common law was based on judicial precedent. Do you understand? So, as common law continues, the king's courts are the ones that apply the common law. Because just like I told you, it is the king that sent his commissioners to go around the state, the country, and started ruling people with their own experience and judgment and all those things. Do you understand? Because they are king. Okay, so thus it is applied in the king's court. Then over time, common law became very harsh, meaning if you come with a case and your case has not been heard somewhere else, or your case is not in that particular writ, that is what they call writ of someone. This one I just give you, but you need to understand. Writ of someone, writ. Sorry, that is what we call writ. If your case is not in that read, then you have a case. So example of those cases that does not have a case is breach of trust or breach of contract. If you have done it, you did not do anything, you don't have a case in common law. So people felt like, this common law is harsh, or is not doing us what they want. Then they stop going to common law, they start going to the king's court. So they'll start going to the king's palace. If they go to the king's palace now, the king will now be telling them to go and meet the chancellor. Then who is the chancellor? Chancellor is more of like a spiritual advisor to the king, which were trained in Catholic. You understand? So if they go to the chancellor, the king, if they go to the king's palace, the king now will now refer them back to the chancellor. And the chancellor is now hearing what they have and giving them justice based on fairness and natural conscience, that yes, that is a breach of duty now. Yeah, he cheated him now, so he should. So that's why in equity, in common, there is a doctrine that says he who comes to equity must come try. Equity will not suffer a wrong without a remedy. Meaning, be just will be remedial. Whether it is wrong, there must be. You understand? So anything you do, you'll be remedied. I'm just giving you this. So after in a continuous form, people now stop going to the common law. They continue to go to chancellor. They call it Lord Chancellor. Lord Elfindon, I've forgotten his name. So in that regard, Lord Chancellor became very busy. So he created a court that is known as the Chancery Court. Do you understand? So what they do in that Chancery Court is that they apply equity. That's to make equality and to do justice in a fair way, in a natural conscience way. Do you understand? So now, the common law people, which are the king's court, became very angry and they started questioning the judgment of equity. That's the Chancery Court. Do you understand? These two courts now start having confliction. And all of them, they have their source. It is the king that tell people to start going to the chancellor, and it is the king that assign people to go around the states. Then why is this? Then after that, the Judicature Act, they sit down and they make one act that brought together common law and equity in one area, where equity comes to mitigate the harshness of common law. Where common law is harsh, equity will now make it soft so that it will be easy to apply. So that is it about common law equity. I waste my time here so that I will explain to you, because this thing will follow you till your 400 level. So if you had it, please make sure you understand it and you. So let's go to the note. Common law, with strict sense, refer to the rigid legal rules developed by English King's Court. You understand? The English King's Court are the one that developed common law, and remedies were limited. There were no much remedy in common law. Example of the remedies that were not there is damages for breach of contract. If you breach a contract, there should be damages. Do you understand? So this is just common law. Then equity developed by the Court of Chancery, just like I told you, Chancery Court, Court of Chancery, and it was based on conscience, fairness, and justice. Equitable remedy include some of these equitable remedy that comes, like some of the equity that were applied were what? One, injunction. Injunction means order to stop something. For example, someone want to demolish your house, equity will stop him from doing that. Specific performance, that order to do the act. For example, you and someone had a contract and he refused to do it, or he refused to abide by his promise, then equity will force him to do that. Then, and trust. Trust means, for example, you and your uncle is holding you the money that your father died and keep it for you. Then that trust is there and he must pay. So that's all about common law and equity. So interplay and application, how they are connected. In modern legal system, the principle of equity are integrated with common law. So like I told you now, the common law and the equity are integrated with one another to achieve what? More flexible and equitable administration of justice. Example of equitable remedy include injunction, it is just like I said earlier. So now let's go. This is another classification of law and is the public and private law. Another classification of law, which is the public and private. This classification will give you based on the relationship between the government and the people. There is the government and the entire citizen, which is public law, and the government and a separate aspect of the society, which is private law. Do you understand? So public law means the law that applies to all. That's the relationship, the law that governs the relationship between the people and the government in general. And private law is the law that applies, that governs the relationship between the government and some aspect of the society, some part of the society. For example, marriage people. Not everybody is married, right? And also contracts, people that are into business. Not all everybody is into business. And so on and so forth. So these are private law and these are public law. So let's look at it. Another fundamental division is between public law, that's the law regulating the states and its relationship with its individual, like the state and relationship with individual, and private law, laws governing relationship between individuals, like individuals, not the state in general. So public law include constitutional law. You see, constitution is for all, right? Administrative law is all. Criminal law is for everybody. For example, the 1999 Constitution established the separation of power and the statute, blah blah blah, etc. An example of pass. That's about that. So, example and application. Example of public law include constitutional law, etc. Then example of private law comprises areas such as contract, law of torts, and property law. This is just it. So I've explained to you. Public law are laws that regulate the relationship between state and the people and individual. Laws that applies to all the individual in the states. Do you understand? Then private law are laws that regulate the relationship between individuals themselves. Like it's not apply in everybody. Okay. So this is it. Let's go to the next. Then another classification of law is between the civil law and the criminal law. What is civil law and what is criminal law? So the division between civil law and criminal law in a fundamental sense, not to be confused with civil law tradition, is fundamental. Like knowing the difference between civil law and criminal law so that you will not be confused about the civil law tradition. That's the one we learned in types of, because in types of law that are applied is very important. So when we say civil, it means law that apply to civilians. Okay, then um in that regards, again, civil law, there it laws that applies that was originated from Rome. So please take notes. You understand? So civil law govern dispute between individual, providing remedies such as damages, injunction, and specific performance. Its aims is to restore the injured party. So that's civil law. Regulate the relationship between individuals. Do you understand? that's trying to mitigate, trying to restore the balance that was disturbed. But criminal law is regulating relationship between the states and criminals. For example, when someone committed a crime, then it is between him and the states. But when you injured someone, then it is between you and the person. That's civil law. Then criminal law between the criminal and the state. Civil, it's really between two parties. Do you understand? So that's in this regard. This is based on the crimes that occurs. Okay. So civil law governs dispute between individuals, providing remedy. Like it governs dispute between two parties. So if Mr. A and Mr. B had a quarrel, it's just about civil quarrel. But if Mr. A injured, slapped, or hit Mr. B, then it's criminal. Now it is criminal law that will govern you. So criminal law involves offenses against the state or society. When you offend the state or you offend the society, then you have committed a crime, punishable by fine, imprisonment, or capital punishment. So you can either be punished by fine, imprisonment, or capital punishment. But in civil law, there is no punishment. It is only remedy. Please understand the difference between civil law and common law. Civil law is about individuals. When you commit, when you did wrong in civil law, it is not crime. It is called tort. So if you do some, if you hit someone, sorry, if you did something wrong to another person, if you do something wrong to another person, you do not commit crime. You commit tort, T-O-R-T, and that tort, how will you be punished is by remedy, not they will send you imprisonment. What are those remedy is they will you will pay damages, or they will give you injunction, or they will ask you to do a specific thing. But if you commit a crime, now it's between you and the state. That's why we have civil case and criminal case. Okay, civil case between parties, two parties, party A, party, that's the plaintiff and the defendant. But criminal case is between the criminal and the state. You understand? So that's it. So criminal law involves offense against the state when you offended the state, punishable by fine, imprisonment, or capital punishment. For example, criminal code, etc. This is just something you need to read. What are the key differences between them? The burden of proof is higher in criminal cases. So if you commit a crime, you are supposed to prove your point beyond reasonable doubt. Do you understand? Beyond any iota of doubt. But if it is in civil law, you just have to balance probability. You have to balance the probability as probably he has committed it. You understand? So that's the main basic difference between civil and criminal. So the burden of proof is higher in criminal cases, where the prosecution must prove guilty beyond a reasonable doubt, whereas civil cases requires proof by by preponderance of the evidence. The objective of civil law are primarily compensatory or remedial. Like in civil law, they just want to compensate you or to remedy the situation that was lost, aiming to restore the injured party to the position they were. But in what's called this thing, the harm occurred. While criminal law focus on punishment and deterrence. So criminal law, it focus on punishment rather than punishment and deterrence. Deterrence means stopping others not to commit it. This is something you learn further in legal system. So another classification of law is substantive law and procedural law. What is substantive law and what is procedural law? Before we proceed, substantive law, these are just laws that explain what are rights, what are obligations, what are duties, what are things to do and what are things not to do. These are substantive law. Then procedural law, these are laws that tells you after anybody breach your duty, then you can follow this process and sue him. If anybody cheated you and did not do the right thing, you can follow this way, and sue the person. So that's substantive law, laws that explain what are right, wrong, good, bad. Then procedural law, then when this right, wrong are breached, you can follow this process to get justice. So Substantive law defines rights and obligations, while procedural law provides mechanisms to enforce them. Do you understand? So when your right and when your rights are being infringed, then you can follow procedural law to make sure you enforce that right on that person. Do you understand? Substantive law example, Section 33 of the 1999 Constitution guarantee rights to live. Section 36 guarantee fair hearing. Okay, so these are example of substantive law. Procedural law example, the administration of criminal justice, like how you can sue a criminal from the beginning to the end. That's the administration of criminal justice. Act of 2015 provide detailed rules on arrest, detention, trial, and sentencing. So you see the criminal rules. They will arrest you, they will detain you, and they will give you trial, and then you'll be sentenced. The Supreme Court in this case, in AG Federation versus Guardian newspaper, stressed that this is something. So another classification of law is written and unwritten law. Laws that were written and laws that are not written. Okay. So written law include codified statute, constitution, like something that is written in codified form, and regulation. Nigeria written law is laid by the 1999 Constitution, which is supreme. This is one of an example of written law. Then unwritten law encompasses customary law and judicial precedent. For example, the decision of Lewis versus this. I'm seeing very well. So in a nutshell, when we say something is written, meaning that is a particular paper or code or document that you see there. But unwritten meaning you cannot find it anywhere. It's just like a tradition. Can anybody bring me a paper that has written all the rules and regulations of Hausas or Fulanis or Yorubas? There is nothing. Then that is an example of unwritten law. Do you understand? Then the one that is in Quran, Bible, or the one in the Constitution, these are an example of written. Do you understand? So please take note. Then the next thing is customary law and Islamic law. This is based on laws that are also applied in different areas. Okay, so customary law consists of unwritten community-based norms categorized by court provided they pass test of validity. So customary laws are unwritten community-based norms. Like in every community, they have their norms and tradition, but they are not written. So this is customary law. But it is accepted when it pass test of validity. What is the test of validity? One, repugnancy, incompatibility, and public policy. Do you understand? All these are when it does not go against the repugnancy test. This repugnancy test is about natural justice, equity, and good conscience. So that's the repugnancy test. Repugnancy test is natural justice, equity, and good conscience. Please take note. Repugnancy test is natural justice, equity, and good conscience. So any customary law that did not go against natural justice or equity or good conscience, then it is accepted. Then incompatibility and public policy, meaning if it is not compatible with any laws, then it is accepted. If it is, then it will not be accepted. Okay. Then again, Islamic law applies in personal laws matter across Nigeria, particularly in northern states, and in penal matter in states that have adopted Sharia penal code, etc. So that's about customary law and Islamic law. So the global tradition. Comparative study requires awareness of other legal tradition. Roman Dutch law applied in South Africa and formerly in Ghana emphasizes right emphasizes codified principle with common law influence. Okay, this is an example. Chinese law heavily influenced by society's legality reflect Confucian value and state authority. Islamic law, as in Saudi Arabia, in the supreme source of legislation. This comparison helped Nigerian students understand diverse diversity and global interconnection. So important of classification of law. Classification of law is not merely academic, aid in understanding sources, application, and limits of laws, like the sources, the application, and limit of laws. In practice, is determine jurisdiction, whether a case lies in Sharia court, customary court, or high court. So that's the simplest thing. So if you know the classification of law, you know that this case is supposed to be Sharia court, this case is supposed to be high court, and this case is supposed to be applicable remedy and procedural requirements for legal education. It provides a structured way to comprehensively to comprehend the complex and legal system. So that's it about this note, and please follow us. Don't forget to subscribe, and thank you very much. See you on the other class.